Welcome to Legally Speaking with me, Tarun Nangia. Today, we are going to discuss one of the most watched judgments by corporate India. A lot of businesses, industrialists, promoters, general counsels, people investing in India were watching this judgment. It is known as the judgment in a section of batch matters before the Supreme Court challenging various provisions in the Prevention of Money Laundering Act. And we are going to discuss all these issues, including the twin conditions for granting bail under PMLA, namely known as Section 45, which was revived by the amendment after Justice Nariman gave the Nikesh Tarachand Shah judgment and Parliament amended. All those things we're going to discuss today. As we all know, this judgment was delivered by a bench of Justice A.M. Khanwilkar, Justice Dinesh Maheshwari, and Justice C.T. Ravi Kumar. What are the implications of this judgment? How should we understand this judgment? Will it be, in a sense, will people file review petitions? All of that will be known. A lot of people want to keenly watch this show to know what happens ahead, because this is a judgment that has far-reaching implications for the industry. And I am very happy today because the panel that I have today, all three of them have argued before the Supreme Court of India and this very bench and raised various points. And that is why they will be able to give us the right picture. May I welcome Senior Advocate Amit Desai, who joins us from the city of Mumbai. Good to see you, Mr. Desai. I have with me Senior Advocate Vikram Chaudhary. He is not Indian, but presently in Bombay, I am told, to argue some matter. I have with me Advocate Abhimanyu Bhandari joining me from the city of Delhi. Good to see you. And without wasting much time, let me request Senior Advocate Amit Desai, your first initial reaction on this judgment.
Tarun, thank you for inviting me on this program. Undoubtedly, this judgment is a significant judgment, much awaited for the last 6 or 7 years, especially since PMLA, as I've been mentioning earlier, has been the flavor of the season for the last 6 or 7 years in this country. And I think everybody was obviously wanting some clarity on where this law will go, but largely in the context of the exercise of the power of arrest and in the context of the bail law. Before I comment on those aspects of the matter, I think I would like to bring some balance to the noise, if I might want to call that has gone around in the country over the last few days in relation to this judgment. When you look at this judgment, and we must recognize what the court was doing, because a lot has been said about the court in the last few days in relation to the judgments. It's important for us to bring some balance to the approach and understand the approach that the court was taking when it rendered the judgment. The court was essentially concerned with the question largely of the constitutional validity of various provisions of the law. And it was not concerned at that time with the abuse of the provisions of the law, and primarily in the context of arrest, in the context of attachment. And therefore, when one looks at the judgment from that perspective, what the Supreme Court was essentially called upon to do was to examine whether on constitutional diktat, the law can stand the test of the fundamental right violations or not. It was not, therefore, I emphasize, dealing with the question of the abuse. What we see on a daily basis, which actually has riled up the passions across the country, is not as much about the law per se, as much as about how the law has been used and in what context it has been used. And that is an entirely different subject matter and a story to be considered. Take the example of the case of Zubair, where the Supreme Court had occasion to deal with the question of the exercise of the power of arrest. And you look at that judgment very carefully, all that the Supreme Court there said, that it is important that you to draw the distinction between the power of the arrest and the exercise of the power of the arrest. And when we deal with the exercise of the power of arrest, it is about how you ensure that the criminal justice system is being used against the citizens of the country. But that itself does not mean that the power of arrest as a matter of law is bad or arbitrary or unconstitutional. That is the distinction that needs to be borne in mind when you look at this particular judgment. The judgment essentially, therefore, upheld all the provisions that were argued before the court and said that they're constitutionally valid. While doing so, I must say that there are aspects of the law in the judgment which are many of the safeguards that are being brought in here. And that is, let me give you one or two small examples of how there is a certain amount of balancing that has also been brought about. When we see the provisions relating to attachment, while there's obviously something to be said about certain aspects of the judgment, but let's look at some of the positives of the judgment also. Let's look at it in the context of the power of attachment. Now, there are large number of cases where properties have been attached and remained attached for more than 180 days. The provisional attachments have gone for more than 180 days. Now, the Supreme Court has now categorically said that that provisional attachment is only valid for 180 days. So when we are seeing these adjudication proceedings, and in many of them, they tend to continue beyond the 180 days, the Supreme Court has settled the position saying that the provisional attachments are only for 180 days. So they enhanced and confirmed the safeguard that was provided for in the law. Let's take another facet of attachment. When they talked about the question of confiscation, that means after the adjudication proceedings, and there is a proceeding under Section 8 where a show cause notice is issued. And the question that comes about is, at what stage do you actually deal with the property which is now which has been attached, and there's a confirmation of the attachment. The Supreme Court has again, in a sense, protected the property and protected those in possession of the property by saying that to a large extent, except for exceptional circumstances, the person should not be dispossessed from the property until the trial is over. It's only in exceptional circumstances that a person can be dispossessed from the property. Now, when you look at these two aspects in relation to property, what the Supreme Court did do was to ensure that the safeguards are adequately met, and that some of the safeguards which needed some kind of strengthening have also been strengthened in the context of the provisions of law, while upholding the constitutional validity of the law. Take, for example, the case of presumption under Section 24, because a lot is being talked about the reverse burden of proof, etc. There are two areas where you talk about the reverse burden. One is in the context of the 45(2), which is the bail law, and one is in the context of the trial, which is under Section 24 of the Money Laundering Act. The court has articulated that presumption arises only when there are what it calls three foundational facts which must be established by the prosecution before the presumption can come into play. And those foundational facts are very significant foundational facts where the burden is on the prosecution to establish those. So in a sense, the court has balanced that particular presumption and not inverted the presumption as is being suggested or talked about. So you see some of these elements in the judgment, which I think we must be fair to the Supreme Court, that the Supreme Court has recognized those and in certain areas clarified them and strengthened the safeguards that were there. So there is much to be said about it. Please understand, this is a legislation which is necessary for any country. Okay, we can't run away from the fact that this legislation is necessary. It is often commented that would you take the example of that case of the import of narcotics of 3,000 crores at the Mundra port. Now, if the main brain was arrested, would there be a criticism that the power of arrest was misused? Now, if you strike down the power of arrest, then even that kind of a person will get the benefit of that particular striking down. So the court had to balance that to say that we can't hold that the power is unconstitutional, the provision is unconstitutional. We have, in every criminal investigation, there's the power of arrest. The question really is about how do you use that power? How do you exercise that power?
Thank you for that.
That is the real issue So there are safeguards, and there's a comment to be made about one or two other issues which we will do as the show progresses.
Thank you for that detailed opening comment and also highlighting the positives of the judgment for the audience. May I request Senior Advocate Vikram Chaudhary for his first comment on this judgment?
Well, taking the cue from Mr. Desai, a senior and a doyen, I would echo his thoughts, and I'll take it into yet another perspective. And that perspective, I feel, is that as lawyers who tend to argue on validity of provisions, we also implore the court to either read down or read into the provisions. Precisely on many of the facets that were highlighted before the Supreme Court, the provisions have been either read into, or they have been read down, or some kind of safeguards which already existed I think they have been accentuated, highlighted, so that there is some kind of a balance. I would say the judgment of the Supreme Court has raised a pivotal issue, which is the strengthening the institutions. So what is the institution? The first institution, the first threshold is the investigating agency or the arresting officer. The second institution is the prosecution, the public prosecutor. Third institution is the institution of defense counsels like us. And of course, the fourth major stakeholder would be the judiciary. Now, on all steps, it is, as Mr. Desai very aptly put, existence of power is one thing. The exercise of that is quite another. So now the power is there, but how, when, which way to exercise? We must have transparency. We must have a robust mechanism. There should be checks and balances at their level. The judgment has actually thrown, to my mind, a lot of responsibility on the shoulders of the Enforcement Directorate. They have to come out very, very clean. There are safeguards which are highlighted to a very great extent. Then the similar role by the public prosecutor. As students of law, we remember the famous lines of that Shiv Kumar Hukam Chand, where the Supreme Court said that public prosecutor's duty is entirely different than that of the defense counsel. Even if he misses some point in favor of the accused, the public prosecutor may winch it to the fore and tell the court that, well, there is something in his favor. We require that kind of independence in the prosecution, and our role as defense counsels also has to be much fair and objective. And we now would like to see the judiciary rising to the occasion and calling a spade, where they feel that there is some kind of transgression. It must be condemned in unequivocal terms. There are balancing aspects in the judgment itself, whether it is the power proceeds of crime, the definition. Not everything is proceeds of crime now. The words used are no assumption. The definition has to be construed strictly. That there is another balance. There can't be, must be proceeds of crime. Value versus equivalent value concept. There are so many things in that judgment which has actually laid to rest many controversies. And I would, of course, the end is also the beginning, a new beginning. We would like to see how it evolves further and is implemented.
Thank you.
Yes.
Thank you for that opening comment. We'll revisit you again for the other issues and comments about the judgment. I'll go to Advocate Abhimanyu Bhandari, who also argued the matter before the Supreme Court bench. Mr. Bhandari, your initial comments on the judgment.
Yes. Thank you, Tarun. Tarun, once when I started reading the judgment, I felt that there are hidden gems for every defense lawyer. And there are lots of parts of the judgment which a defense lawyer should carefully read because it can really help the accused. For example, we talk about big cases where you see a big personality getting arrested. What we don't necessarily talk about and doesn't come in media is the consequence of a very big man getting arrested. Because once a big honcho has been arrested, after that flows a number of attachments that come. Those attachments may be the dealings of that person with many people. Some of them may be bona fide purchases for value without notice. So, for example, a big company goes bust. You arrest the owner of the company because you feel he's done some siphoning off and he's viewed in a fraudulent manner. But then what happens after that are a number of attachments coming, which you and I don't talk about. It's not in the media. But then that starts impacting the lives of many people who get roped into an investigation when they should not really be concerned about that investigation because they've, let's say, bought a property with consideration, or they've done a transaction years before this whole scam erupted. So we have to ensure that this act, while fulfills its agenda, as Mr. Amit Desai said, that catches that person who was dealing with 3,000 crore worth of drugs on Mundra port. But then the consequence of that is that a lot of other people who may be in the ecosystem or who may be directly or indirectly connected with that person, not knowing that he's a drug dealer, may get embroiled in that act. And I think one very big breakthrough that has come in this judgment is an argument that I made. And I'm very happy and delighted it got accepted, Tarun, because I saw that on a daily basis, is that when an adjudicating authority confirms an attachment of a property, people were told to move out of their houses. So there were people living in their houses for 10 years. This was their only residence. I've seen people being told, go away within 7 days from your own house. I've seen running factories getting into some kind of a problem where all the receivables that the company will receive will be attached by the ED. So the company is not able to pay its laborers, its staff, its office people. So that impacts those office people also, employees also who've been working in a company. Now the judgment clarifies that after an attachment, you can't take possession of the property. The person who's accused or the person whose asset has been attached, and remember, in many cases, the person whose assets are being attached may not be criminally liable. He may just be suffering. He may be an innocent person possessing proceeds of crime. So he should not face the consequences till there is a conviction and a court has decided to confiscate his property. So what the court has done, and this is absolutely remarkable, is that the court has said that, look, although Section 8(4) says that ED will forthwith send a notice and tell the person to vacate the property, but we're going to read that down and we are going to say that no, he has a right to enjoy his property. And in only exceptional circumstances could you even start thinking about telling that person to go. So para 73, I think that is what of the judgment is very clearly on this point. And I think that will bring a huge relief. Remember, Tarun, we have an appellate tribunal which is not functioning, if I'm not mistaken, for last 2 years. Yes. And there are lots of people out there waiting to either get their property back or to get some kind of an interim order so that they don't have to vacate their property. This is going to come as a huge relief. And it balances the competing interest because there's no point telling a person to go out. You've attached his property, so you've ensured that it's secured, subject to final orders. So once a final order is there, then of course, if a court feels it's laundered money and it's a laundered property, then the court can take it away at that stage. But what if you acquit the person or you say that, no, this was not property involved in money laundering? Then why should the person be deprived of enjoying that property? Okay, he can't sell it to somebody else. He cannot encumber it. So you attach it. And that's exactly what the Supreme Court has said. And I think that's a very, very big breakthrough as far as this whole act is concerned.
Thank you for that.
Second aspect. Okay, as we go ahead, we'll bring up more points.
Yeah. So now I'll go to Senior Advocate Amit Desai. The judgment in the initial pages also speaks about the Nikesh Tarachand Shah judgment delivered by Justice Nariman and says that the Parliament amended Section 45. And when after that amendment, relief for bail was prayed, the efficacy of Section 45 was put into issue. Mainly, some courts held that twin conditions have been brought back, and that is why bail can't be granted. Can you clear the air for us? Where has this judgment resurrected Section 45 and said, okay, now twin conditions go on for every ED case? Could you clear it for the audience?
So far as twin conditions are concerned, after the amendment, the twin conditions were always there. All that this judgment has done is to affirm the existence of the twin conditions.
Okay.
So the distinction between Nikesh Tarachand and factual position and what has happened here. When Nikesh Tarachand considered the validity of that particular provision, there was the section actually correlated the bail and the overt act with the scheduled offense and not with the money laundering offense itself. So therefore, the Supreme Court at that point said that there's no correlation between the act, the bail, and the act itself. All that has now happened is that the language was changed to say that instead of the scheduled offense, it says that you have to now examine the question in the context of the offense under the Money Laundering Act itself. So now there's a correlation with the object of the act and the bail provision. As a result of which, there was a very technical argument that was canvassed to say that whether once there is a judgment of the Supreme Court which strikes down the provision as ultra-virus, can the legislature come back and resurrect the provision? All that it did was to correct the error that was brought to its notice by the Supreme Court and struck down when that particular provision was struck down in Nikesh Tarachand. So that is all that has happened in that sense. And what you will notice from this judgment is that this twin condition has been around in legislations for the last nearly about 30-40 years. In series of legislation, in fact, in the judgment itself, at a footnote, the court has actually identified nearly about 24 statutes in which the twin conditions exist. So there is nothing unique or unusual about the twin conditions. The question that we argued was that in the context of an offense which was punishable with 7 years, would you need such a draconian provision or not? Because the principle of law which has evolved under the general law is that if there's an offense which is punishable with 7 years, which is under the general law, the ordinary rule is to grant bail. Now, if that was the ordinary rule, then should, in relation to the Money Laundering Act, which is also an offense punishable with 7 years, that ordinary rule not apply. The Supreme Court has taken a view that based upon all the material that was placed before it, that the Money Laundering Act is a heinous crime. It has, in a sense, elevated that crime to a crime which affects the economic sovereignty and integrity of a nation, like a terrorist act, which deals with the integrity and sovereignty of nation. It has elevated that. Now, that was a philosophical issue based upon all the material that it gathered from the United Nations, the FATF, etc. Having said that, they said that it's legislative policy, and therefore we treat it as a very heinous crime. It is for the parliament to take a different view in the matter. Our contention was that if it's 7 years, please read it down. But there's another aspect to this that I think we'll, and I would say this as a lost opportunity, if I might be allowed to say that, permitted to say that. When we're dealing with the question of personal liberty, I think the question is, whilst the legislation, of course, is important, it is necessary for every country to protect the financial integrity of a nation. I think there's no debate on some of the issues. But when you're dealing with somebody's personal liberty, the question is, was there possibility for the court to actually bring in some clarifications, some kind of safeguard, which opened up the ability for senior judges in a high court, which is a kind of argument which I had canvassed but was not accepted, that whilst that a senior judge in the high court could then say that, yes, the role of these different people is different, I'm willing to consider grant of bail to somebody whose role is less severe than those who are the principal perpetrators of a crime. That is the issue that came up for consideration, where there was an opportunity for the Supreme Court to say that we will balance the rights of fundamental rights of parties and clarify this aspect of the matter. There's one other clarification which they did do, is to ensure that there's a registered predicate offense, because otherwise we were seeing that in many cases, even without a registered predicate offense, the PMLA authorities used to come in and start their investigation. As Mr. Chowdhury rightly put it, this legislation requires the enforcement director to do a lot of thinking. There is a lot of responsibility that has been cast upon the enforcement directorate to now examine as to how they will exercise their powers. And that is very important. But when you look at it in the context of here, what was the other lost opportunity? When you dealt with Section 19, which is the power of arrest, could the Supreme Court have further clarified that there is a safeguard, but in what kind of circumstances would you actually exercise the power of arrest? But it's possible that the court has not, that issue never really came up. And there's an opportunity in other matters for that issue to be resolved and clarified in this context.
Point well taken. Point well taken. With this, we bring to an end part 2 of our series on the PMLA judgment. In part 3, we'll continue our discussion with the same panel, where we'll delve further into the issues that have come up in the judgment and what are the implications of these issues. But I would like to thank Senior Advocate Amit Desai, Senior Advocate Vikram Chaudhary, and Advocate Abhimanyu Bhandari for joining us on the show, and looking forward to see you again in part 3. Thank you so much for joining in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.